It looks like Mr. Tanksley and Ms. Lalu Amin are both in the courtroom, and we are ready, so you may proceed. Don't forget, Mr. Tanksley, turn your mute button off so we can hear you.
There you go.
Thank you, Your Honor. Sorry about that. May it please the court. First, I want to address a small housekeeping matter. After the petitioner's reply was filed, the respondent filed a motion to file a surreply brief, which I believe the following day was denied by the court. And then on, I believe it was the final day to request oral argument, the request for oral argument was filed by the respondent. It's the only request that's been filed in this matter. In this request for oral argument, the respondent requests oral argument pursuant to the rule to address, essentially to address what she wanted to place in the surreply brief that the court denied. I have prepared, assuming that since there's no order and nothing has, I don't know of any rule that addresses this, I have prepared based on the assumption that this is a normal oral argument without any special provision to argue matters that were not briefed.
Mr. Tanksley, the way we do things is we rely on the briefs of the parties that have been accepted, the arguments that have been made in the briefs. If there was something that you feel was inappropriately raised by the other side, or the other side feels there's something inappropriately raised by you, you can certainly highlight that. But as far as we are concerned, there's your argument, there's a response, and then you get the last word on rebuttal.
I'll proceed, Your Honor. And I'd like to reserve 5 minutes for rebuttal, please.
Very good, Mr. Tanksley.
This is a second tier appellate review from the circuit, the 10th Circuit, acting in its appellate capacity, having issued a mandate to the circuit, to the county court, the trial court, after the appeal of the trial court's original final judgment, final monetary judgment. Accordingly, pursuant to controlling case law, we need to show a violation of a clearly established principle of law. In this case, it's the law of the case, the judgment that the circuit court had affirmed, and then we need to show a resulting miscarriage of justice. In this case, by applying the abuse of discretion review upon being asked to enforce its own mandate, affirming a monetary judgment after the trial court completely nullified the legal or judgment interest component on remand, the circuit court effectively found that the trial court had discretion to ignore the mandate, that the trial court was, only subject to the reasonable person standard, and that the mandate, effectively, the circuit court did not treat the mandate as the law of the case or really binding on the county court, nor upon the circuit court itself as the court that had issued the appellate mandate and affirmed the opinion, the judgment. The final judgment was simply a monetary judgment. There was, no further action taking place in this case, and no in the trial court.
Mr. Tanksley, isn't the issue
If the judgment is affirmed, then what apparently arose thereafter was, how can I pay this judgment? And apparently, absent some cooperation on that, a motion was made to deposit the funds into the registry. And the court can decide how to disperse and under what circumstances to disperse. That's the order that we're looking at in this case, isn't it?
The reason I disagree with that, Your Honor, is that it is false, and it is clearly a false assertion made by counsel for the respondent at that time, leading up to the trial court stripping the interest component from the judgment, that he made any effort at all to pay the judgment with interest. Now, we took his testimony was taken for the trial court, and he had filed a motion, and we've set forth his testimony. He was cross-examined. He had filed a motion before the trial court asking to be able to deposit simply the principal amount of the judgment into the court registry and have that suffice as satisfaction in full. At the hearing when he testified, and he had said in his motion that he had tendered, that he had sent checks to us. Now, aside from the fact, the question is as to whether checks are sufficient tender, we don't need to deal with that because he testified at the hearing that he never sent anything but copies of checks. And he never sent, and the total of those checks were simply the principal amount of the judgment, no interest. Now, the respondent took the position that they, from the very beginning, were just trying diligently, I'll say, to satisfy the judgment. But the record is clear, and you can see exhibits, I believe, C and D in our appendix, where he filed post-trial motion to avoid the judgment. Now, he filed those motions about 2 months after the judgment was entered. We know that 2 months after the judgment was entered, he was opposing the judgment, even though, of course, it's very interesting because the judgment was issued based on a proposal for settlement that the respondent had served and the petitioner had accepted. In any event, 2 months after judgment, interest had accrued, and he was at that point opposing the judgment. Now, how I don't understand, there's no way to reconcile this claim of the respondent that they were diligently trying to make every effort to pay and to satisfy the judgment, and the petitioner was avoiding them, ducking them, when 2 months after the judgment was issued, they had pending a motion for relief from final judgment and a motion to join real party in interest. The respondent was trying to bring in a party. Apparently, they had made a mistake by not paying off. This was a property damage to a car claim, and apparently the insurance company, which was covering the respondent's representation, had overlooked the legal requirement that the insurance company take care of the lien, pay the lienor whenever there's a reimbursement for property damage on a car that has a lien. I guess that's what happened, because when you look at these motions that I'm talking about that were filed 2 months later, they're trying to bring in this third party. They're talking about bringing in a company, Triangle Auto. They're saying that Triangle Auto holds title to the vehicle. But that, of course, wasn't anything related to litigation. Any concern over whether someone would get, whether the respondent would receive title to the car when the judgment was entered, that was not part of the proposal for settlement. We just had a final judgment. We were concerned about the amount of the judgment because there were two different figures in the proposal for settlement. Several days within the week after these two motions were filed, we filed our notice of appeal. And the respondent didn't do anything else with respect to these motions opposing the judgment. And they did not oppose the judgment in the appeal. But the record is clear, and the testimony of counsel for the respondent is clear that they were not making payment or trying to make payment. They were opposing the judgment at this point. Now he testifies in his at the hearing as well. He was asked about these two motions opposing the judgment 2 months after it was entered, and the counsel for the respondent, attorney that had filed these two motions, said in a somewhat ambiguous way, I believe, to the effect of, well, we just decided to abandon those motions and not take them into the appeal and not maybe seek relinquishment of jurisdiction so that the trial court would be able to address them. So I believe they merged. I'm certain that they merged into the appellate decision, or at least that they were just waived. The respondent had a chance at that point to file a cross appeal or to, as I said, seek relinquishment of jurisdiction. So no, I disagree. It's utterly clear that the court was being misled by the attorney for the respondent, and this court should not be misled by the attorney for the respondent making the exact same arguments here today in their briefing or in their response to the petition. They're doing the exact same thing, and in fact, they're claiming that that again. They just continue to claim that the petitioner has avoided, has ducked. It makes no sense to me. I'm sorry, but we have a judgment. The attorney apparently made a mistake. The attorney for the respondent, somebody made a mistake, and they weren't happy that they didn't get title, apparently, but that just never was mentioned. And then they've engaged in this chain, this sort of a subterfuge on the trial court to obtain this ultimate order to avoid paying interest. Now, at the time that the appellate mandate issued affirming the final judgment, that was about 2 years later. My calculation is at the date that the mandate was recorded back in the trial court, we had earned interest of I believe 2.5 years. It came to a total of $1,686.91, and we had never received any check. We had never received any proposal, and this is, of course, in the record. There had never been any proposal to pay anything more than the principal amount of the judgment.
Mr. Tanksley, are you finished?
No.
Just to let you know, you have about a minute left before you start eating into your rebuttal time.
Okay, thank you. So clearly, now in the we was talking about the miscarriage of justice, miscarriage of justice issue in the respondents' response. They say we're seeking years of interest. Well, it's been a bunch of years. Alternatively, that's effectively the miscarriage of justice. And Your Honor, I understand. I'll finish in a minute, and I'll just take what's left in rebuttal. So we're seeking that's the miscarriage of justice as defined in their own response. We're seeking years of interest. Well, we know that at the time that the two motions were filed seeking to undo the final judgment, that we'd already earned 2 months of interest. So how can there's clearly error if we don't even get those 2 months. There's clearly error there. There's no question that at that time, they were not making any effort to pay this judgment. And I believe that the testimony in as well, I don't think you really need anything more than seeing these two motions in the record opposing the judgment 2 months in. But if you did, you got the testimony of the attorney for the respondent saying that effectively he just misled the court when he filed the motion saying that he had tendered payment and we had avoided it. I'll wait for the rebuttal time.
Very good, Mr. Tanksley. You'll have 4 minutes for rebuttal. Ms. Lalu Amin.
Good morning, still morning. May it please the court. Sarah Lalu Amin on behalf of the respondent, Sherry Nelson Peacock. The circuit court's PCA affirmance of the trial court's ruling and rejection of the law of the case theory argued by the plaintiff was not a departure from the essential requirements of the law, resulting in a manifest injustice. It's a well-supported ruling on a well-supported record of plaintiff's counsel's evasive conduct obstructing payment of settlement funds. And we respectfully request that this court dismiss or deny the petition. For context, this case comes from a property damage settlement from almost 15 years ago. The plaintiff's vehicle was deemed a total loss and was compensated accordingly. The petition doesn't really acknowledge the origin of this case coming from settlement and coming from a proposal for settlement specifically, but that's how the judgment here came about, and that's important. It's precisely the amount that was agreed upon by the parties pursuant to the proposal for settlement, down to the penny. And that's important here. It's important because it shows there's no basis for the plaintiff to ignore the defense's repeated efforts to make payment here, and no basis to appeal the judgment amount. And that's admitted here that that's what was appealed in that first appeal. It's exactly the amount agreed upon by the parties in the proposal for settlement, but counsel for the plaintiff did that too, resulting predictably in a PCA. So this is far from the type of case where someone rejects a tender because they're going to exercise their appellate rights, as was the case in this court's opinion in DeVolder, and which we cited that case in our response, and the BEM case as well, which is addressed in the district court's opinion, and then the Florida Supreme Court's opinion there reversing, which is noted in the reply brief. And I did want to make that point here and address that. That's the same situation. Someone there had appellate rights. Here, there were no appellate rights to challenge the judgment. It was exactly the amount agreed upon by the parties. And so I'd like to draw the court's attention, if I may, to the proposal for settlement itself. It's at page 5 of the appendix to the response. Paragraph 4 provides, the relevant conditions of this settlement are that acceptance can only be made by agreement to entry of a judgment against Sherry Nelson Peacock in the amount of $6,739.85. That's the exact amount that was subsequently entered. Paragraph 6 provides, the non-monetary provisions of this settlement are that the plaintiff will instruct his or her attorney to execute a satisfaction of judgment upon receipt of the settlement proceeds. So the agreement here, the contract, is for the plaintiff to agree for judgment to be entered in that amount and to execute a satisfaction of judgment, not upon execution and collecting on a principal and interest and collecting on that money while they pursue an appeal of the amount of the very amount they agreed to, but acceptance of the settlement proceeds. And that's what was attempted here over and over again. My client attempted to make that payment all along. Those checks were drawn and waiting, subject to being reissued in a different format if that's what the plaintiff wanted, but the plaintiff would never respond. And the trial court made those findings. There were no savings to my client or my client's insurer in waiting. Those checks were drawn and just waiting to be dispensed to the plaintiff if they would just accept. And that's proven by the defendant ultimately asking to just deposit the funds into the court registry. But on the flip side, it appears that the plaintiff saw this as an opportunity to make money. By pursuing this baseless appeal, challenging the judgment amount expressly agreed upon here. And interestingly, all we have on that is the plaintiff's description of the first appeal as having been as to the amount of the judgment. This being presented on a law of the case theory, you would expect that we would actually have the briefings from that first appeal. There was a brief and dismissal submissions that were filed that ultimately led to the PCA in that first appeal, but we don't have those here. Those aren't provided in the record. So notwithstanding that, after the first appeal, my client was still attempting to make payments. The trial court allowed my client to deposit the settlement funds into the court registry. And it's that order, Judge LaRose, as you noted, it's that order that was appealed below under the guise of asking the circuit court to enforce its mandate from the first appeal the plaintiff lost. And so the primary arguments in the proceedings now before this court and before the circuit court below were along those lines: enforcement of mandate, the law of the case, that somehow in losing that appeal and not presenting this argument of interest, that the mandate implied that the trial court had to award interest when there was never a basis to pursue that appeal in the first place, as some vehicle to collect on interest. So while the plaintiff continues to pile on more and more law of the case law, including non-compliant supplemental authority that was just provided a few days ago, that doctrine has no application here. That case law is exactly what one would expect, where an issue is decided and then there's a remand and the trial court does something different. And that's not what happened here. I'll address just briefly the supplemental authorities submitted. The discount sleep 5th DCA case applied the law of the case where the issue on appeal had been argued in the trial court and in a prior appeal, and the 5th DCA held that the ruling was the law of the case because the argument was presented and decided. The Ramsey v. State case cited as supplemental authority from the 4th DCA is a typical example of a trial court's or an appellate court's enforcement of its own mandate. There, the court's prior opinion directed on remand for the defendant's competency at trial to be determined non-protunct as of the date of trial. The trial court on remand used a different date, so that was not in compliance with the appellate court's mandate. Very different from what we have here, of course. Here, the plaintiff attempted to get the trial court to ignore the dispositive facts about counsel's refusal to accept payment by arguing that none of that matters because of a mandate. There's never been a mandate to that effect, and there never should be. What happened here on the plaintiff's counsel's part was improper and unnecessary, and the trial court correctly recognized that. So other than the law of the case or enforcement of mandate argument, the plaintiff doesn't attack the merits of the circuit court's affirmance. Doesn't argue that law of the case aside, the court didn't have the authority to do what it did. To the contrary, the plaintiff conceded at page 21 of the initial brief in the circuit court, pardon me, had Peacock ever tendered the funds of sufficient amount, although the plaintiff argues it had to be in a specified form, which of course the proposal for settlement didn't provide, and had plaintiff rejected tender, then judgment interest should have told as of the date of the rejection. The record shows this rejection happened after the settlement, both before and after judgment was entered. There should never have been a judgment that collected interest because these settlement proceeds were attempted to be paid as they had been intended all along to be paid by check before the judgment was entered, and then the satisfaction of judgment would be entered along with the judgment. And that's often the case when you have these proposals for settlement. So nor has the plaintiff argued that the trial court's ruling wasn't based on competent substantial evidence. They acknowledge that the trial court set forth a factual basis for its ruling in detail. They simply argue that the trial court should have disregarded everything before judgment, essentially considering this matter in a vacuum. The trial court properly considered the full context of this matter, including the plaintiff's counsel's ongoing refusal to accept payment and evasive conduct, and made well-supported rulings on the evidence. And I do want to address briefly the post-judgment motions that were raised. That's not a matter of payment. Payment was going to be made anyway, and there was just some question of whether there was compliance with the law. Wasn't a mistake necessarily made on anyone's part, maybe perhaps the plaintiff in representing ownership of the vehicle. But regardless, those funds still remained ready to be paid. It was just a matter of who they would be paid to. And in any event, that was abandoned. But the payment had been tendered on an ongoing basis, well before that and well after. So for these reasons, unless the court has any questions for me, we'd respectfully request that this court dismiss or deny the petition.
Very good. Thank you, Ms. Ludlow. Mr. Tanksley.
Thank you, Your Honor. There's counsel's suggesting that payment was going to be made anyway. And then she follows that with, but we were trying to decide who to pay. More or less, that's what she says. We were trying to decide who's the right person to pay. Well, Angela Ruiz was the person that had the final judgment against Ms. Peacock. She was the person to pay. They were fiddling around. She says they were trying to decide, well, we may not be supposed to pay Angela Ruiz regardless of the fact that she's on the judgment. And again, we know 2 months later, when these motions to avoid the judgment, to overturn the judgment were filed, they had not paid. Now, counsel is saying we were trying all along, even though we were trying to overturn the judgment and decide who was going to get paid. It doesn't make sense. 2 months later.
Let me ask one question, Mr. Tanksley, because in reviewing the appendices that the parties have provided, I saw that there was an offer, there was an acceptance. There was a letter to you indicating who do we make the check payable to and what's the tax identification number. Was there any response along the lines of what you just said, which is send me the check, I don't need it to go through my trust account, send it to Ms. Ruiz, and here's the tax identification number?
I believe our response was that we had previously instructed them that we wanted payment not by check, but by certified check or cashier's check, collected funds.
Is that something that is required? No, is that something that's required, that it be tendered by cashier's check or certified check?
The law clearly provides that satisfaction of judgment does not have to be accepted by the judgment creditor in the form of bank checks. In other words, a judgment debtor can't take a regular check to a judgment creditor and say, satisfy the judgment, give me my satisfaction of judgment. Of course, it doesn't work that way. We wanted to have it done.
Were you being asked to execute the satisfaction of judgment before the check was tendered?
He actually did. He actually did, and I believe that's in the record too. He sent satisfaction of judgment and asked for it to be signed and returned. I believe that was even addressed at the hearing. And he said, well, I just didn't think I could trust this guy. Now, I'm digging deep into my recollection to say that, but I believe there was discussion along those lines. But we were asking clearly for certified funds and had told him from the beginning that regular checks weren't going to work, but he never sent us regular checks.
I'm looking at Mr. Crawford's letter to you of October 31st, 2005, that basically says, how do you want the check made payable and what's the tax ID number? It doesn't say anything about a satisfaction of judgment, but I don't want to take the rest of your time on this issue. You've got about a minute left, so go ahead.
I would say that, well, tax ID, okay, thank you. Tax ID number is irrelevant. We had a judgment, they had to satisfy it and with interest. And all he was doing again was proposing to, he was asking, you know, if we had responded and said, okay, we'll take payment without the interest, and I guess he would have been really happy, but that's not how we responded. We demanded the interest all along. The proposal for settlement does not control. What controls is the final judgment. The proposal for settlement could have contained any number of additional conditions, but the final judgment is what was appealed. It's what was affirmed. They didn't request to have any additional terms placed into it. If they did, of course, it was affirmed as written.
Very good, Mr. Tanksley. We are at the end of the time. Thank you both for the arguments. You may leave the meeting and this session is concluded. Thank you very much.
Thank you.